A U.S. judge dismissed a crypto money transmitter case, and the core question stays open. Michael Llewellyn built Pharos, a non-custodial cryptocurrency donation platform. He wanted a federal court to confirm, before launch, that running it would not make him an unlicensed money transmitter under federal law. On March 25th, a U.S. District Court in the Northern District of Texas told him the question was not ripe enough to answer. The court granted the government's motion to dismiss without prejudice. Llewellyn, the judge found, could not demonstrate a credible threat of prosecution under federal law governing unlicensed money-transmitting businesses. Recent DOJ guidance suggesting authorities would not pursue enforcement against crypto businesses for end-user actions undercut his claim of imminent harm. The case is gone. The question it raised is not why a developer sued preemptively. Llewellyn's argument was straightforward. He wanted to operate a tool where users control their own keys and the platform never takes custody of funds. Under traditional banking law, money transmitters are entities that receive and transmit funds on behalf of others. Non-custodial software does not do that, at least not in the way the statute was originally written to address. But enforcement actions over the past 2 years have blurred that line. Tornado Cash developer Roman Storm faces conspiracy charges that could carry 40-year sentences, and prosecutors in that case have argued that writing code that facilitates fund transfers is itself a form of money transmission. The Samurai Wallet founders face similar charges. Llewellyn did not want to wait until he was indicted to find out where the line falls. He asked the court to draw it first. The standing problem. The court's dismissal did not say Llewellyn was wrong. It said he had not shown enough immediate danger to justify a ruling. The DOJ's internal guidance, while non-binding, was enough for the judge to conclude that prosecution was not imminent. Llewellyn pushed back publicly. A non-binding DOJ memo is no substitute for real legal certainty, he said, adding that his lawyers were exploring options for how to proceed. The dismissal was without prejudice, meaning Llewellyn can refile if circumstances change. If the DOJ rescinds its guidance, or if a new administration signals a shift in enforcement priorities, the same legal arguments could return to a courtroom. The industry lined up behind the case. What made this case unusual was the breadth of support. The Blockchain Association, Paradigm, the DeFi Education Fund, and the Uniswap Foundation all filed amicus briefs. These are not fringe actors. Paradigm is one of the largest crypto-focused venture firms. Uniswap is the dominant decentralized exchange. The Blockchain Association represents dozens of companies. Their collective message: the industry needs a judicial answer to whether writing self-custody software creates money transmitter obligations. Without one, developers are left guessing, and guessing wrong means federal felony charges. The amicus briefs also pointed to the chilling effect. Projects with strong legal teams can afford to take the risk. Solo developers and small teams cannot. The ambiguity does not create a level playing field. It creates one where only well-funded entities ship products. What the Tornado Cash trial means now. With the Llewellyn case dismissed, the Tornado Cash prosecution becomes the most likely vehicle for judicial clarity. Roman Storm's trial, where prosecutors argue that deploying a non-custodial smart contract constitutes money transmission, will force a court to address the core question head-on. The difference is the stakes. Llewellyn asked for a declaratory judgment. Storm is fighting to stay out of prison. The legal principles are similar, but the procedural posture could not be more different. A ruling in the Storm case will carry far more weight, but it will also be shaped by the specific facts of Tornado Cash, including its use by North Korean hackers, which may limit how broadly the precedent applies to other non-custodial tools. For now, the legal status of non-custodial developers sits in the same gray zone it occupied before the Llewellyn filing. The DOJ says it will not prosecute, but the statute has not changed, and a future administration could read it differently. What this means for crypto card and wallet builders. The money transmitter question is not abstract for companies building spending products. Crypto cards that let users spend directly from their own wallets sit at the intersection of payment processing and self-custody. If a non-custodial interface that routes a transaction is money transmission, then wallet-connected card platforms could face the same legal exposure. This is why self-custody card providers like MetaMask, Gnosis Pay, and Ledger have structured their products carefully around the custody question. The Llewellyn dismissal does not change their legal risk, but it does mean the industry is still waiting for a definitive answer.